for your mission, Inspector General. I am Lai Jing Yi, Agent 03412238. Our team accepts your mission to assess whether the current law strikes an appropriate balance in protecting the interests of mortgagee and mortgagor regarding the law on foreclosure, possession and sale. To begin with, the mortgage is a contract of loan between the parties where there is a legal date of redemptions and closes the mortgagor's legal right to redeem. Essentially, the legal date of redemptions is the mortgagor express contractual promise to repay the sum due on a certain date plus accrued interest. If the mortgagor fails to repay the debt owed, the mortgagee may exercise their rights to foreclosure, rights to possessions, and right to sale to the mortgage. Firstly, the right to foreclosure exists in the case of an equitable mortgagee who has taken an agreement for a legal mortgage, and the effect of a foreclosure is to vest the mortgagor's estate in the mortgagee and to extinguish the mortgage as mentioned in Section 88 of the Land of Property Act 1925. There are two-stage process, namely the foreclosure nisi and the foreclosure absolute. For the foreclosure nisi, an action will be brought to the court and requires the mortgagor to repay a mortgage within a specific period, normally of 6 months. A failure to do so will lead to the foreclosure being made absolute, and the mortgagor's interest in the property will be extinguished. A foreclosure proceeding could only be effected upon a court's order as laid out in Section 88 subsection 2 and Section 89 subsection 2 of the LPA. Per Justice Hammer, the mortgagee has no right to possessions until the court gives it to him. The rule of foreclosure is deemed to be harsh, and thus the mortgagor would seek relief from the courts of equity. Therefore, the court may grant mortgagor the right of redemptions even though the foreclosure decree was absolute, as mentioned in Spur and Langton. Applying to Mr. and Mrs. Horton's situations, it is not definite that the property will be taken away by the mortgagee through foreclosure. They will be granted the right of redemptions regardless of the absolute foreclosure. Henceforth, they will still have the chance to reopen the foreclosure at the court's discretion. However, as illustrated in Campbell and Holyland, the foreclosure could only be reopened in exceptional circumstances, subject to the court's discretion, as it differs from case-to-case basis. For instance, Lord Cranworth refused to lay down the general rule regarding when will the court open the decree of foreclosure. Besides, the mortgagor's interest will be protected when the courts allow an order for sale in lieu of foreclosure under Sections 91, subsection 2 of the LPA. If such a sales occur, the proceeds will be distributed according to Sections 105, where the mortgagor will receive the surplus funds after the mortgage is paid off, if the value of the property is greater than the mortgage debt. This is third in favor of the mortgagor. Nevertheless, the right to foreclosure might also favor the mortgagee instead of the mortgagor. As aforementioned in Section 91, the effect of a sale in lieu of the foreclosure may well to overcompensate the mortgagee by resting in his property worth more than the debt. Furthermore, pursuant to the originally enacted Section 36 of the Administration of Justice Act 1970, the protection conferred on the mortgagor does not apply to foreclosure, despite that this Act countered with the enactment of the Section 8 subsection 3 of Administration Justice Act 1973, which allowed a foreclosure claim. It is only partially successful as it applies only to installment mortgages. Nowadays, the remedy of foreclosure is similarly unpopular as it is draconian. Its harshness causes hardship to the mortgagor, especially during the COVID-19 situations. The mortgagor may be burdened with the repayment of mortgages by suffering from unstable income. Moreover, this remedy is redundant as the ability of the court to order sale in lieu of the foreclosure had meant that the disappearance of successful foreclosure actions. In essence, the courts have attempted to balance the interests of mortgagor and mortgagee in the foreclosure actions through Sections 91 of LPA. However, only to an extent as, if ever exercised, it tends to favor the mortgagee. Thank you. The next agent will now take on the mission.
I'm Liew Lok Yee, Agent 03404116. I'll now talk about the right to possession of the mortgagee. Besides exercising the power of sale to realize its security, the mortgagee also has the right to possession of the mortgage property. In practice, this right is usually exercised before a sale to eject the mortgages from the property to secure a better market price in order to realize its security. Essentially, the mortgagee's right to possession, as provided by Justice Hamren in Formas and Dudley Marshall, is an automatic right under common law, whereby a mortgagee may enter into possession before the ink is dry on the mortgage. In other words, a mortgagee may take possession of the property at any time, even when the mortgagor is not in default, subject only to the terms expressed in the mortgage agreement. There is a danger whereby such a draconian right may be arbitrarily used by a capricious mortgagee to seek possession as a prelude to sale. In situations when a non or a minor default occurs, possession can be obtained under the right to possession without obtaining a court order. This is largely detrimental to the mortgager's interest. Applying this to the scenario video, this means that the bank could render Mr. and Mrs. Horton homeless by subsequently selling away the house after taking possession.
Hi, I'm Ying Chia, agent 0340880. In this part of the video, I will talk about the statutory controls available on the mortgagee's right to possession. The absolute common law right to possession is criticized as obsolete in today's society, in which the nature of mortgages has tremendously changed compared to the era before the 20th century, where mortgages were mostly granted over property when the mortgagor already owned an interest. As we know, nowadays, mortgage-funded home ownership has become the norm. Accordingly, protection has been provided for mortgagors who have taken out residential mortgages with the introduction of Section 36 of the Administration of Justice Act 1970, as amended by Section 8 of the Administration of Justice Act 1973 to mitigate the harshness of the law on possession. Under Section 36, an application for possession of a dwelling house may be suspended, adjourned, or postponed by the court in its discretion, provided that the mortgagor is likely to be able to pay any sums due under the mortgage within a reasonable period. Since nowadays most of the residential mortgage specifically provide that a mortgagee may enter into possession only when the mortgagor defaults, Section 36 gives the mortgagor time to remedy the default. This change, which moves away from the traditional absolute right to possession, mitigates temporary undue hardship of a mortgagor. This is particularly helpful for mortgagors facing temporary unemployment and financial difficulties caused by the current COVID-19 pandemic situation. Moreover, in Cheltenham and Gloucester Building Society and Oregon, the court have liberally established that a reasonable period can be decided on the facts of each case and may even be the whole of the remaining mortgage term. A guideline of considerations, including reasons behind the accumulation of arrears, were established to determine what a reasonable period is. Thus, the court may take into account the reasons behind Mr. and Mrs. Horton's accumulation of arrears, which are, firstly, Mrs. Horton's recent loss of physical therapy job, and secondly, Mr. Horton having to quit his construction job due to a knee injury and also the need to pay for his surgery's medical bills. On the flip side, a suspended possession order under Section 36 benefits the mortgagee as well. For instance, the bank in the scenario video may get a possession order, although suspended, and at the same time another order requiring Mr. and Mrs. Horton to repay the arrears and stick to a schedule for future payments. As such, the courts, by embracing the social policy behind Section 36, have shown willingness to balance the mortgagor and mortgagee's interest, which is to enable mortgagors to complete the purchase of their homes on one hand, while emphasizing the mortgagee's right to enforce payment on another. However, though Section 36 benefits mortgagors, in reality, it is described as inadequately drafted for four main reasons. Firstly, this relief is only limited to mortgages of dwellings, not commercial premises. Secondly, it is only applicable in situations when the mortgagee applied for a possession order from the court. Thirdly, though the condition precedent of paying sums due in a reasonable time appears to balance the mortgagor and the mortgagee's competing interests, the mortgagor is, however, expected to demonstrate either that the arrears could be discharged by periodic payments while maintaining future payments, or that the property could be sold off quickly and debts can be discharged from the proceeds of sale. Hence, Section 36 is only useful for those who experience a short-term difficulty and are likely able to cope after unprecedented disasters. Fourthly, any suspension or adjournment must be for a fixed period and cannot be left indeterminate. This is rather unhelpful in regards to the current COVID-19 situation, as it may continue indefinitely. Now, after evaluating the protections and inadequacies of Section 36, Agent Lok Yee will proceed with other possible measures which may protect the mortgager's interest. Thank you.
Besides those statutory restrictions, there are other limitations on the mortgagee's right to possession that may arise in very special circumstances. Although technically, the mortgagee is regarded as having an estate in the land, and this gives the mortgagee an absolute right to take actual possession of mortgage property, Lord Denning in the case of Queen and Not B suggested that a mortgagee will be restrained from getting possession except when it is sought for the realization of the mortgagee's security. Obviously, this contradicts with the mortgagee's absolute right to take possession. However, this is a clear example that the court desired to strike a balance to protect mortgagors by encouraging a narrow approach to possession, which legitimates the exercise of a wide discretion to prevent the mortgagee from obtaining possession other than for the purpose of sale. Furthermore, in Cheltenham and Gloucester Public Limited Company and Crowds, the court held that there is no power to suspend a mortgagee's possession outside Section 36 of the AJA 1970 when the sale would not pay off the entire debt. Yet, Crowds did not overrule POC and mortgage services funding that relied on a wide discretionary power under Section 91 of the LPA 1935 to deny the mortgagee's right to possession through a forced sale of the property, even though this would not discharge the capital debt. Martin Dixon has contended that Section 91 is particularly useful in negative equity situations like Crowds, where Section 36 is frequently unhelpful because the lender's security is at risk. Therefore, it may seem that if Mr. and Mrs. Horton apply to sell their property under Section 91, it is possible that they could suspend the mortgagee's possession order, even though they are not able to put out a sale that will pay off the entire debt. Moreover, a mortgagee's possession of property could not be ordered if the property is mortgaged by joint mortgagors like Mr. and Mrs. Horton, where, in fact, the mortgage turns out to be binding on only one of them due to undue influence. This seems to favor the mortgagor because if one of them, as co-owner, could prove that they have an overriding interest, the mortgagee could not obtain possession. In order to strike an appropriate balance between both the mortgagors and mortgagees, other statutory restrictions on the mortgagee's right to possession exist in particular circumstances. For example, the Limitation Act 1980, Consumer Credit Act 1974, Rent Act 1977, and the insolvency legislation. It is surely unacceptable in this day and age that the mortgagee can simply take possession of mortgage property and evict the mortgagor with no other obstacle. Therefore, mortgagors are likely to assert Article 8 of the ECHR with increasing regularity. The courts now have to consider the application of human rights defences in possession claims, even though there is no doubt that Article 8 presents as an additional obstacle to the mortgagee's right to possession. That is all from me and Ying Chia for the right to possession. Thank you.
Hello everyone, my name is Yong Hau, agent 0340280. So in my part, I'll be covering the mortgagee's power of sale. When a mortgagor is in serious default on the repayment of a loan or in breach of a contractual promise on a mortgage, the law provides power to the mortgagee to recover the whole sum due by selling the mortgagor's property. So in practice, there are usually clear and express terms clarifying that there is power of sale by the mortgagee. However, if such clause is not included in the mortgage, the power of sale is implied by virtue of Section 101 sub 11 Law of Property Act 1925, as long as the mortgage was made by way of deed and there was no provisions excluding the statutory power in the mortgage itself. Now, it's important for us to understand that in Mr. and Mrs. Horton's scenario, we have to see whether the legal date of redemption has passed, or in cases of installment mortgages, whether there was installment in arrears. After that, for the power of sale to be exercisable, conditions stipulated in Section 103 Law of Property Act 1925 has to be fulfilled. The power is exercisable if there is default in payment for 3 months since notice was served by the mortgagee, and 2 months interest under mortgage is unpaid, and lastly, where there's a breach to the provisions in the mortgage deed. So what happens after the sale? In this regard, we shall refer to Section 105 Law of Property Act 1925, where it stipulates a sequence of the liability that have to be met as a result of the proceed of sales. However, in Mr. and Mrs. Horton's case, it is essential to bear in mind that the bank, as a mortgagee, should not make any profit from the sale if the land sells for more than the debt. Fundamentally, the capital gain from the sale of the house will have to be used to make payment of all expenses and costs incurred by the sale, followed by the payment of principal debt and interest of the mortgage. And lastly, the residual profit of the sale will have to be given to the person entitled under the mortgage, which in this case, it will be Mr. and Mrs. Horton. Now, there has been a debatable source of controversy as to whether the court's order for stay of possession is mandatory when the mortgagee execute power to sale. Essentially, Section 101 Law of Property Act 1925 does not require the mortgagee to obtain court order on possession before sale because mortgagee is allowed to transfer the legal title of the mortgage property even if mortgagor remains in possession. As in Horsham Property Group Limited case, the court did not allow the mortgagor to rely on the statutory protection for lost property under Section 36 Administration of Justice Act 1970 because the court clarified that such protection can only be applicable when there is a possession order by the mortgagee before the sale of the property. This is harsh and draconian, as mortgagor will not be entitled to any protection if the mortgagee decides to exercise the power of sale, even if the mortgagor is in actual possession of the property. On this basis, Professor Patrick mentioned the need for reform, as the exercise of statutory power of sale under Section 101 Law of Property Act 1995 have exposed and confirmed gaps in the present law which enable mortgagees to circumvent the requirement in which is widely but erroneously assumed to exist. He further contended that an order from the court must be obtained if the mortgagee wishes to take possession of the home of the mortgagor in default and sell the property. As pointed out by Rachel, there were various efforts made in this regard. For instance, the introduction of Home Repossession Protection Bill in February 2009, as well as the consultation paper published by Ministry of Justice suggesting the mandatory procedure of the mortgagee to obtain order from the court before the proceeds of sales. Despite the effort to mitigate the undesirable part of the current law on power of sale, there is still no valid authority to require the mortgagee to obtain court order before selling the property. Therefore, as the law stands at present, the bank will not need to obtain court order if they decide to exercise their power of sale. With that, I conclude my part and pass it on to the next agent. Thank you.
Hi, I'm Ern Chee, agent 0340298. I will be elaborating on the protection of mortgagor's interest during the exercise of power of sale. When the mortgagee exercises the power of sale, there are safeguards provided to the mortgagor to protect their interests. For example, under Section 104 Law of Property Act 1925, once the power of sale under Section 101 LPA 1925 arises, the mortgagee can convey a good title to a purchaser. However, a mortgagor can restrain the sale by establishing some element of impropriety or bad faith on the part of the mortgagee in the exercise of its power of sale. In contrast, if the sale has been done in good faith, it cannot be set aside. Also, in Waring, Lord and London and Manchester Assurance Company, it is shown that an injunction restraining the completion of sale by paying off the debt will not be granted unless it is proved that the mortgagee entered into the contract in bad faith. In Mr. and Mrs. Horton's situation, if the bank conducts a sale towards the property under a bad faith, the sale would be struck out by the court to protect the interests of the mortgagor. When the power of sale arises and is exercisable, the mortgagor has to rely on equity to protect their interests and rights. As the conduct of sale is a matter of considerable importance to the mortgagor, one would expect certain duties to be imposed upon the mortgagee with respect to the exercise of power of sale. Therefore, the mortgagee is under a duty of care towards the mortgagor to obtain the best price reasonably obtainable. However, in Capmere Brick Company and Mutual Finance, it was mentioned that where there is a conflict of interest, the mortgagee can give preference to his own interest over the mortgagor's interest, but subjected to obtaining the true market value.
Also, in Bishop and Blake, the mortgagee who breached the duty to obtain the proper market price is liable to account to the mortgagor for the shortfall in price and make compensation to the mortgagor. Apart from that, when the mortgagee was subjected to conflict of duty and interest, he had to show that all reasonable steps were taken to obtain the best price reasonably obtainable. However, despite the need to obtain the best price reasonably obtainable, a mortgagee is not obliged to wait for an increase in the value of the property, as mentioned in Sylvan Properties and Royal Bank of Scotland. In Mr. and Mrs. Horton's situation, if the bank exercises the power of sale, the mortgage property has to be sold at the best price reasonably obtainable, or else the court will render the sale invalid to protect the mortgagor's interests. There are also statutory safeguards towards the mortgagor's interest, whereby the mortgagor has the right to sell the mortgage property for the purpose of repaying the mortgage debt, and to have it against the mortgagee's wishes. This was provided under Section 91, Subsection 2, LPA 1925, whereby any person interested in the right of redemption of a mortgage property, including the mortgagor, could apply to the court for an order of sale. This is particularly valuable to a mortgagor whose debt is increasing, as it slows down the increase in debt owed to the mortgagee, therefore alleviates the burden held by the mortgagor. In POC and Mortgages Services Funding, it was mentioned that it is the court's wide and unfettered discretion under Section 91, Subsection 2 to order a sale of mortgage property. In exercising that discretion, the court would have regarded what was just and equitable. Therefore, the court may reject the sale if the mortgagor intended to delay the repayment by applying for a sale in mortgage property, as shown in Cheltenham and Gloucester and Crowds. In Mr. and Mrs. Horton's situation, they can apply for a court order to sell the mortgage property, even if the bank opposes it. Therefore, this sums up the balance between mortgagee and mortgagor's interests in the sale of mortgage property. And I will pass it to Agent Ying Chia to conclude. Thank you.
In conclusion, a foreclosure action, possession or sale of the mortgage property is a calamitous event to mortgagors. Hence, it should not be exercised in an unfettered manner. It is inevitable that the current law on foreclosure, possession and sale has moved away from a hard and fast rule. Firstly, the harshness of the law on foreclosure has been largely circumvented by the courts, usually ordering for sale instead. Next, with regard to the power of sale, legislative intervention and equity have provided safeguards on the mortgagor and the mortgagee's interest. Finally, although a mortgagee's immediate right to possession remains, the once absolute right to possession has been reduced into remedy to possession due to statutory control and a plethora of case laws. As such, it is submitted that the current law not only focuses on not putting the mortgagee's security at risk, but many efforts have been made in order to strike an appropriate balance in protecting the interests of both the mortgagee and the mortgagor. This is the end of our mission. Thank you for tuning in, Inspector General.